Hi everyone, I'm Boston 25's Bob Ward, and I'm joined now with noted Boston criminal defense attorney, Elyse Hershon. Thanks for joining us.
Thanks for having me.
And we have been covering the Brian Walshe murder trial. This is the Boston 25 Brian Walshe murder trial podcast, and we've been covering this trial since even before it began. And here we are now, today, on Monday, the jury just a few hours ago finding Brian Walshe guilty of first-degree murder. It could have found him not guilty. It could have found him guilty of murder in the second degree, but it found Brian Walshe guilty, murder one, and it took about 5 hours and 45 minutes for this jury to reach this verdict. Were you surprised the jury came back in less than 6 hours?
Not that surprised that it was a quick verdict. In a first degree, it is unusual for it to be such a quick verdict. I think it was anticlimactic. It sort of felt like it was going to be this big reveal when the verdict comes in, and it sort of felt not surprising given just the overwhelming evidence and how graphic the evidence was that we heard.
Well, we also had on the verdict slip, we had first degree and second degree. And it looked like there might be room there if a juror felt uncomfortable with, going with first degree, which carries the mandatory life no parole sentence, that somebody might be a compromise verdict to go down to murder two. Do you see it that way?
That's a great question, and I do agree that second-degree murder usually is a compromise verdict, although usually it's a compromise verdict if it's between a first and a manslaughter. They compromise on a second. The judge's instructions, and defense attorneys don't love this instruction, but the standard instruction from the judge is to find the defendant guilty of the most serious charge that you can find him guilty on.
Right.
I'm paraphrasing, but that's tough language. So that's basically telling them if you think that he intentionally killed Anna Walshe and there was a cool-off period, bump it up to first. That's how I interpret it. That's how a lot of defense attorneys interpret it. And it's a tough instruction. It's sort of telling the jury not to compromise down. On this verdict slip, as we know, there was no manslaughter. There was no self-defense. Imperfect self-defense where it could have resulted in a voluntary manslaughter or heat of passion. He killed her in a fit of rage. That would have allowed a little bit more wiggle room for the jury. I don't think they had much of a choice here.
All right, so I wanted to talk to you about the moment that this all happened. So I was in the courtroom when it took place, and there was no advance notice from the court that there was a verdict. I started seeing some activity about 15 minutes before the verdict came down. Some movement in court, and then all of a sudden we saw the defense come in and the prosecution come in, then Brian Walshe come in, and something's up, but I didn't know if the jury had a question, and that's why everybody was getting called in. It wasn't until the judge announced in court, we have a verdict. And one of the things that I noticed was court officers were surrounding Brian Walshe before the judge got on the bench. You have been involved in 17 murder trials. What is it like in that moment when that court is filling up, you get notice that there's a verdict? What is it like for you? What is it like for your client?
It's extremely difficult and intense. It's a moment where news is coming. It's either going to be the worst news that your client ever hears in his life or her life, or the best news they'll ever hear in their life. And those few moments, which usually is anywhere between 15 and 30 minutes between when the light goes on to say that they're ready to come out and then the judge comes out, it feels like an eternity. It also is very stressful because you finally took a breath after the trial's over. You have a minute to sort of gather yourself and relax a little bit, and the blood pressure is through the roof, the intensity is through the roof, and everything is riding on that moment. First-degree murder is life without parole. They're either walking out that day or they're never seeing the light of day. It's pretty heavy.
You know what I found a little bit jarring was trying to figure out why everybody was coming back, if it was going to be a question or if it was going to be a verdict. I did not know. None of the reporters knew. When Brian Walshe came into the courtroom, he knew there was a verdict, and he walked in like he does every single day, not a care in the world, sat down, next to his defense attorneys, was smiling actually, and it looked like he was joking a little bit with his defense attorney. But he must have known that this jury was going to come in and have a verdict, whether it was going to be for him or against him.
So and I can't speak for these particular lawyers, but in general, defense attorneys, we tell our clients, do not react. So whatever the verdict is, don't react, take a deep breath, breathe, Whatever it is, if it's a conviction, we'll appeal. If it's not, don't jump up and down for that either. So we really don't want a reaction from our clients. There's a lot of people in that room, usually from both parties, from the victim's family, and no matter what the case is, it's always sad for the victim's family there as well as usually the defendant's family. So there's people from both sides, and they are also instructed not to react or have any outbursts. So it is a very solemn period of time, but Brian Walshe was likely instructed not to. Joking around with the lawyers, I've been blasted all over the news with my client smiling at me during a first-degree murder trial. It just happens to be some moments of levity, but it does not mean they're not taking it seriously. It's just unfortunately it's sometimes that happens.
And it might be a way to relieve some anxiety that Walshe must have been having, because I did notice that when he was let out of the courtroom, he looked at his mother quickly, but his face was red, and he looked like he was scared, and off he went. And what a tough moment that is, because it's all real now for him, right?
And it's very intimidating too, because the court officers, and you had seen this too earlier today, when the verdict is coming in, but you don't know what the verdict is yet, all of the court officers, particularly in a case where there is a mandatory sentence, like a first-degree murder, all of the court officers and security come in and surround the defendant and surround the defense attorneys. And I don't know if that was clear on the video on the stream today, but they all line up behind the defendant, between them and the rest of the audience, both to protect the defendant, the defense attorneys, from anybody in the audience that might have a reaction, and also to prevent if the defendant maybe would bolt or any type of information. So it happens in all of those cases, but it's very intimidating because the client thinks at that moment that they are going down. They think it's a conviction, and a lot of times they can freak out or get really upset. And it could be a not guilty, but it's always the same thing. The court officers go around them. And if, a lot of the court officers will tell my client directly, we don't know what the verdict is. This is all standard procedure. They hear it, but it is very intimidating to have all these officers around you for the first time during the entire trial. And suddenly the reality, I think, hits.
Yeah, the reality hits. And I wonder what the reality was like for him when he put on those cuffs and was let out the back door of the courthouse as a convicted killer, not as someone on trial,
right,
attending all these hearings, but he knows he's looking at the rest of his life behind bars. Let's back up a little bit and go over just some thoughts on the trial itself. Anna's body has never been found, and that hung over this whole case, from the case, the investigation, but also at the trial. Anna's absence was huge, but I also felt that her absence was felt, because we saw in real time video of Brian Walshe at those dumpsters. We saw him buying the tools that he used to dismember her, and that was uncontested by the defense. Mm-hmm. That was him. That was Brian Walshe doing those things. And when we saw the items that were recovered from a dumpster, I think there were, I don't know if it was 8 bags of trash. It was a high number of trash bags that were pulled from that, was it a recycling center, the compactor? That's where I found a glimpse of Anna. We saw her jacket, we saw her COVID-19 card, we saw her boots, we saw a little remnant of a Gucci chain that was wrapped up in the rug, and most disturbing, we saw her blood and clumps of her hair. And it was at that moment that I felt Anna is here, and she's telling us what happened. But that's just me as a reporter trying to understand what's taking place. It's not often we get first-degree murder trials when there is no body. This was a rare trial.
Very rare.
How much of a hill was that to overcome for both sides?
It was a huge climb for the prosecution. The only way that they were able to get over that is because of really 2 major things: the Google searches, which showed that Brian Walshe knew she was dead and was looking to get rid of her body, and then the video showing him buying the tools and items to get rid of her body and showing her body being thrown in a dumpster. It's horrific to think about. It's worse to see on video. It's very jarring and graphic for a jury to see, for anybody to see. Even as lawyers, we hear and we talk about very gruesome things as part of murder trials. We see photos, etc. But video really hits home a lot harder. It tells more of a story, and it really shows Brian Walshe's mannerisms. We had touched on, shock can appear different in any situation and in any particular person. You and I could react very different to a traumatic event, viewing a car crash or any type of event. And we could both remember different things about it, but if there's a video of it, the jury can see for themselves. So even though we still don't know how Anna Walshe died, the jury has spoken that it was at the hands of Brian Walshe. We know from the defense and from the evidence it was not a bloody, violent death. Certainly if it was in the bedroom, it was not. Was it asphyxiation? Did he kill her with his hands? We don't know. We won't ever know. But the jury has spoken that he did it.
Let's talk a little bit about the difference between direct evidence and circumstantial evidence. And I want to ask you about this because I think a lot of people, a lot of people care about true crime right now. And they hear the term circumstantial evidence and they think that's not evidence. And in this case, there is no direct evidence on how Anna Walshe died. We don't know if she was shot, she was stabbed, if she was strangled, if she was poisoned. No idea. We don't know if it happened in the bedroom, the living room, in the kitchen. No idea. There's a suggestion that the knife they found in the cabinet over the refrigerator may have been the murder weapon, but we don't know. So there was no direct evidence, and the charge was murder. But there was, I'm terming it a mountain of circumstantial evidence that I thought pointed at Brian Walshe. So I guess, number one, you would want to have direct evidence, whether you're the prosecutor or the defense attorney. But circumstantial evidence, if there's enough of it, can be just as powerful as having direct evidence.
Absolutely, and especially if the circumstantial evidence speaks to the defendant's state of mind. State of mind is a huge piece of proving first-degree murder. If you remember that the first element is they had to prove that Brian caused her death, that doesn't have the intent element in it. But the second one is that Brian Walshe intentionally caused her death, and the third one, that Brian Walshe intentionally caused her death after a cool-off period or premeditatively, with premeditation. Those are all state of mind. What was in the person's mind versus was it an escalation and there was no thought put into it? So those Google searches really were almost like a diary of what was in his mind, at least directly after she died. And it was not a stretch to link that to, well, a few hours earlier, what was he thinking based on all of those searches? How gruesome they were, how specific they were, and really how self-serving they were. It wasn't days or weeks later, it was merely hours, if that, after she died. And it really shows the depravity of what was in his mind. So I think the circumstantial evidence, even though it wasn't him confessing, it was not him planning a murder, it was not how to kill someone, how to make something look like an accident, how to kill someone and make it look like someone's missing before her time of death. We don't have that here. That would be much more direct evidence. But I don't think it's a stretch to look at it and say that he was thinking that prior to and before, and this was evidence of planning.
We were saying last time out how important closing arguments are. And I have to say that the prosecution in this case, Yaz, she presented the closing arguments for the prosecution. And she was able to highlight a couple of things that get overlooked. And one of them was an internet search for Anna's boyfriend, Will Fastow, on Christmas Day. And then also searches about emergencies at the apartment complexes in DC where Anna worked. I think those searches, I don't know if those searches were Christmas Day or the days leading up to it, but the story that Brian gave police when they arrived at his door was that Anna left to handle a work emergency at the very places that someone in that house was searching before Anna disappeared. And I thought that was powerful evidence of planning, premeditation.
I agree, and I don't think that made an impact as much during the trial.
Right.
I think there were so many Google searches, there were so many text messages, there was a lot of geographical data through the cell phone. It gets lost, which is why I do think the prosecution did a nice job in their closing pulling out yes, the Google searches were bad, but let me tell you the ones that were way before that that could be evidence of his state of mind leading up to the death. That was pretty bad evidence for him. It was not, open and shut, but it was pretty bad. It gave, the difference between speculation and reasonable inference. Was it a reasonable inference if he's Googling William Fastow? He's already met him. He's already worked with him in the sale of the townhouse and the purchase of the townhouse in D.C. months prior. Why is he Googling him on Christmas Day when that's who she was with and where she was? What's a reasonable inference there? It's a little more than pure speculation that he was looking him up because he suspected they were together. And it's, it was bad. It looked really bad.
So the defense went with, in opening statements, saying that Anna was not murdered. A couple of things. Anna was not murdered, that she died of natural causes, and that on New Year's Day, early in the morning, after the party is over, Jem Lou is gone. They're all lovey-dovey in the bedroom. He comes downstairs to clean up the kitchen, is there for about an hour, comes back and finds Anna dead. Nudges her, is what was described to the jury. Nudges her, she rolls over. He realizes that she is dead. And he doesn't call 911, but instead hatches this plan because he's in a state of shock. Now, you had a dismemberment case that also there was an element of shock, but it resonated with the jury in the light of that defendant was second-degree murder, not first-degree murder.
And he took the stand and explained it.
In this case, Brian Walshe did not take the stand.
Yep.
And do you think that the idea of Anna Walshe just spontaneously dying was unbelievable to this jury?
I think it was unbelievable because there was very little evidence that sudden death was here. It was a complete hypothetical through the cross-examination of the Commonwealth Medical Examiner, the Office of the Medical Examiner. So all the evidence, or I guess the supposition during opening statement about him being downstairs, Brian Walshe cleaning up, going upstairs, nudging her off the bed, there was zero evidence of that. Not just, some evidence or maybe not credible or this and that. Not one person testified the whole trial as to that piece of information. I think the defense put themselves in a very difficult position by promising something in the opening statement. You're going to hear this, you're going to hear that, and then they never heard about that forever the rest of the case. So the judge always instructs the jury in the beginning and at the end. The defense has no burden to present evidence. The defendant has no need to testify, a right not to. It's even in the voir dire and the jury questions. So it's a very important piece. So you don't want to give it away in opening statement that you are going to provide evidence and then fall short of that. That's a little bit more than just don't hold the defendant accountable if he doesn't testify. That's more, well, they promised they were going to hear something either from him or a witness, and it never came. So I think the defense, in the jury's eyes, lost a little bit of credibility there.
What about Brian Walshe taking the stand? That was all, we were talking about this. Isn't he going to take the stand? And it looked like he was going to take the stand, from what we know now, that he was going to take the stand last Thursday, and that morning something changed and he didn't take the stand. Knowing now what we didn't know then, do you think if Brian Walshe took the stand, this outcome would have been any different than it is now?
I think it would have been his only shot because there was nothing else for the jury to even consider in the deliberation room. There was no case to weigh between defense and prosecution. I'm not sure what the reasonable doubt was. The reasonable doubt was we don't know how she died, and there could have, I guess, really hammered the reasonable doubt in the defense's closing. They really were still focusing on that medical event that there was very little evidence of. And I'm sure there was a reason for it. I'm not sure what it was. But I think the reason that you and I were talking about Brian Walshe taking the stand is because of that opening statement. If before the trial we were talking, we would have said, no, Brian Walshe is not taking the stand. I wouldn't put him on the stand. He's got an open case. He's being sentenced federally. There's very terrible facts. He'd have to explain this dismemberment, the shopping trips involving his kids to go shopping with and to lie to police. He'd have to explain all of that, even though all of that was not part of the actual charge. That'd be a lot of explaining to do. But the fact that the defense kind of said, you're going to hear from us about what the case is about, and then it made us question, well, maybe he will take the stand, because as it got closer to the end, the only witness to that theory of sudden medical event would be Brian.
Right.
He's the only one that was in the house after this supposed medical event. He's the only one that could describe what she looked like. You know, was she cold to the touch, like how she rolled off the bed? He's the only one that could have presented or even given that idea to his lawyer. So why didn't we hear from him on that?
It is. I will never understand that. And in retrospect now, from what the judge was saying to the lawyers, she thought he was going to take the stand. She had written some instructions for the jury based on Brian Walshe actually taking the stand. So she went home on Wednesday night expecting that Brian was taking the stand, and then it changed that morning. And then she said, "Well, I don't need this now. Well, you know, we're going to move forward with this case." It's interesting. I don't know if that was strategy or if something changed. Maybe he got cold feet. I don't know.
I don't think it was cold feet. I think this is probably something that was very thoroughly discussed between him and his lawyers dating months back. I think the judge is prepared for anything. The defendant and the defense does not have to answer whether the defendant is testifying until it actually comes down to defense. It's, you know, the Commonwealth rests. It's your turn to present your case. And then they can call other witnesses, and usually the defendant, if at all, which is, it's rare, is called last. So the judge is always prepared for a certain type of instruction with regards to the defendant testifying. The judge also was prepared and instructed the jury before opening statements, if we remember 2 weeks ago, that the 5 elements that the Commonwealth must prove for first-degree murder, the last 2 had to do with that it was not self-defense and there were no mitigating factors or circumstances. That's relating to a manslaughter. Manslaughter is relating to a heat of passion argument that he, you know, caused her death, but not premeditatively, intentionally. They got in a fight. She came at him. He took a knife. Imperfect self-defense, something to that effect. The judge instructed the jury on that because the judge did not know the defense strategy at that time. And then the defense, in their opening statement, said, well, it's not self-defense, it's not manslaughter, it's a sudden medical event. So the judge doesn't even have any preview of exactly what they're going to say in their opening statement. And once the judge did, I think the judge thought, well, this event was that they're proposing, the only witness is Brian Walshe. I'm going to prepare an instruction for that.
Yeah.
Part of that is preparation, no matter what, in any case. But part of it is because the defense basically said it.
All right, let's wrap up on looking backwards. And what do you think, did anything work for the defense in this case?
I think they did the best with the evidence that they had, that they were stuck with. So there's a saying, admit what you can't deny, deny what you can't admit. So they conceded about the dismemberment and the disposal. He also pled to it in the beginning of the case, which I'm still not quite clear why that decision was made strategically. And
why?
then
What's the downside to doing that?
there's a lot of downsides to that. So basically, pleading guilty to that before means it's not on the verdict slip to the jury. So the jury did not have the option of acquitting him on the murder, but convicting him on the disposal and misleading police. We know he did that. He admitted he did that. But why did they have him admit it before the trial? Why not let the prosecution do their job? Why not make them do their job? Hold them to their standard. It's their burden of proof to prove each and every element beyond a reasonable doubt. It would have given the jury at least an option to do a split verdict. They still may not have. So that was something that was questionable. I think a lot of people have questions about that, and I don't think we'll ever hear about that. But I think the defense did a good job with their cross-examination, creating questions about contamination of evidence, that there were a lot of items from the dumpster.
Right.
Some had visible blood on it, some didn't. They were bagged together, 5, 6, 7 items in one bag. Transfer DNA. DNA can go from one item to another. You can touch something in a trash can that was at a murder scene, and that item can end up at the murder scene and your DNA is on it and you were never at that scene. So that's very dangerous to have happen, and it's not good protocol by criminal investigation, by crime scene agents.
Just to be devil's advocate, what would be the difference? So you find in a bag a pair of slippers, I don't know, a bloody rug, some hair, maybe the hacksaw. I don't remember what was found in each individual bag. It's all the same thing. what would be the problem? What's the difference if it was found originally on the slippers and it wasn't on the slipper? What is the problem there?
It could lead to, a difference in theory. So why was there a bathrobe and slippers there that had her biological matter on it, right? So blood evidence, and the clothing that Brian Walshe had said she was wearing when she left for the airport. Why were both those items together? If she were killed in her bathrobe and slippers, then her clothes that she said she left with, that he said she left with, would not have blood on them. He probably got rid of them because to keep up the story that if she's missing, he needs to get rid of the clothes that he said that she was wearing when she left in case they came for a search. Maybe that was, again, not premeditation, but part of the cover-up.
Right.
But if that didn't have blood on it, she wasn't killed in that, then that evidence from the bathrobe and the slippers got on that clothing, like that sort of just creates, it muddies the waters and just creates more doubt and more reasonable doubt as to how she was killed.
Got it.
Was it after she left the house? You're not wearing hunter boots in the house. So if there's blood evidence on the hunter boots in the outfit, was she outside? Was she killed by someone else? Where is the actual crime scene? So it creates a messiness, and especially after the Karen Reed trial and the contamination of evidence there, and they were snow blowing the snow around and all of the potential evidence was mixing together. They could have been much more careful in their investigation and collection of that.
All right, on the other side, on for the prosecution side, what worked? We know the entire case worked, but was there something that you watched and you saw that made you say, boy, there's no getting around this. This is really, really bad for the defense?
Of course, the Google searches were bad, and like you said in the beginning of our conversation, in their closing arguments, they pulled out the ones that were not the obvious ones about, can you identify a body with broken teeth? Can you collect after if somebody's missing? Can you be charged with murder? Those are the obvious ones, but those were post-mortem, so didn't still tell premeditation. Very smart of the prosecution to choose the Google searches that were before she died to show his state of mind, because we never heard from Brian Walshe. He never told us his state of mind, he never told us what happened, but those Google searches are essentially a statement from him in the computer. So I thought it was smart for them to pull that out. I also liked their use of exhibits. Where the screen was set up was actually past Brian Walsh's head, or past where he was sitting, his face, in the courtroom from where the jury was sitting. So the jury had to literally look across Brian Walshe onto these exhibits of these very gruesome tools. And in the same sight line, they're seeing these tools and they're seeing the person that's being accused of using them. So I thought that was effective just in terms of the setup.
All right, so we have sentencing. Brian Walshe now convicted killer. What's left now is sentencing, which is going to take place on Wednesday. There will be victim impact statements, so we don't know if Anna's friends and family will be in the courtroom. If her mother is in the United States, will she be in the courtroom, or is she staying in Serbia and will write something and send it in? What are we looking for? Well, we know that first-degree murder has mandatory life, no parole, so there's not much mystery of what's going to happen to him.
There's not. The judge still has to sentence Brian Walshe on the 2 charges that he pled to before the trial. The misleading a police investigation usually carries up to 10 years. There is an enhancement with a murder conviction. So there's obviously a murder conviction. The judge can add 20 years. At this point, it doesn't matter if she adds 1,000, but she will sentence because that's the proper procedure and how this works. It will be plus 20. I anticipate will be plus 20 years after life without parole. It doesn't affect it because he's not ever getting a chance at parole, as well as disposal of a body. It's a felony, but it's not actually specific to dismemberment. It could be any improper disposal. Dismemberment does not have actually its own specific criminal charge for that.
What about an appeal? This automatically gets reviewed.
There's an automatic appeal. It's probably going to take a year or 2 to even be appointed an appellate lawyer. They're going to go through and look at everything. Appellate lawyers always look at defense attorneys, and if they missed an objection or if there was any sort of ineffective assistance, anytime you lose any type of trial, that's what appellate lawyers look for, and they comb through every single thing. It's inevitable that lawyers miss things on both sides, but they really comb through everything, and I think they're going to take a really close look at that opening statement. And did it almost burden shift from the prosecution to the defense that they were going to put on a case and then they didn't. Does that rise to the level of a valid appeal? So that will be something that they're going to look at, I anticipate.
This case is really interesting, very fascinating, but the main thing to always remember is that a young woman, a mother of 3, lost her life, Anna Walshe, and she is gone. And now her husband is going away too, and in essence is losing his life for what he was convicted for. They have 3 young children. This is a tragedy, really, a human tragedy.
It's terrible.
And it takes a long time to think about and digest it and understand, if we ever can, about what happened. But Elyse, thank you for joining us for these podcasts, helping us to understand these issues and know that there's no such thing as an open and shut case.
Absolutely.
And this is why these trials even happen, and this is why we cover them.
And there's a lot to talk about.
There sure is. Elyse, thank you a lot for joining us.
Thank you, Bob. Thanks so much for having me.